Trying to put in your headphones.
They are in.
Off the mic.
Okay. Would you mind just turning off the mic? Because I'm getting a lot of echo. So you're good. So do you guys want? Let's go over the terms first, from the first study guide, and then let's move on to talk about Federal 78. Sound good?
Yep.
All right. Let us share this screen right here. Okay. So what is a plaintiff?
It's a party that brings in charges into a court room.
And who's a defendant?
I don't want to go.
Fairness.
Defendant's the person accused of the crime.
And what is civil law?
Civil law is civil law doesn't have to do with like default person instead of the item itself. It's the person.
No, you're right. You guys are really good. Do you have something, buddy?
Yeah, sorry, I was trying to find my file. Civil law is so basically like laws concerning private relations between members of a community rather than criminal, military, or regional religious affairs.
Yeah.
It's in contrast of criminal law.
Yep. Yeah, because civil law is more about private relationships rather than necessarily actions taken between private citizens. What is the Court of Appeals? Is it a court of bananas appeals? The puns are back.
It appeals in a federal and state level, kind of.
Can you explain what an appeal is?
An appeal is like, so an amendment is like an add-on. So an appeal is like basically like an opposition.
Yeah.
So an appeal is what makes sometimes a case or something. So it's appropriate because we're talking about courts. An appeal, I find, is what makes things last a case longer in court. There's like I appeal, and then sometimes it's like a legitimate appeal. So then you have to take time and to see if it's actually legitimate or if they finally rule it out. Like it basically is an appeal can be really simple, where the judge overrules it right there and then, or they take time to study it.
If I may add on, like an example for government would be like kind of how you see it. We talked about before with oversight. So it's like a mistake. Well, an appeal is similar to that instead of that, a legislative kind of way. It's more of a judicial kind of way. It's just a mistake. So it's similar to oversight. I wouldn't think so. Would be as an example.
Yeah, it's kind of like past oversight, because it is taking a second look at a situation, whether it be a private case or whether it be more a constitutional issue. For example, Proposition 8 was taken to the Court of Appeals because people thought it was unconstitutional. And so to get the Supreme Court to take a second look at it, they brought it to the Court of Appeals. What is the Supreme Court?
it's the highest law in the land. Like it's where the buck ends there. It's basically you can keep going through it. So it starts off with like district, and then it goes to the state, and then it goes to the Supreme Court. Yeah.
It's the highest federal court.
Yeah.
Mm-hmm. And what kind of cases does the Supreme Court rule on?
Cases that have maybe they've been through like a state level, and then it gets really so like I don't know. Let's see, Supreme Court,
Constitutional issues.
Gay rights didn't they have to go through the Supreme Court?
Uh-huh.
And stuff like that. That basically the state level. I'm sure like the gay rights and stuff like that. It went from like abortion. It can go state level, but then it's really serious, so they take it to the Supreme Court.
So a better way to think about it is to think of them as reviewing constitutional issues. That's the only reason why it would get to the federal level, because it's an issue with the Constitution and what it validates. Because that's they're essentially the keepers of the Constitution and making sure that it is followed validly.
It was like the Supreme Court more lenient in the past because so like not Marbury versus Madison, but the one having to do with the state bank or something, I can't remember. But it seems like they weren't all necessarily as serious, strictly by the. Well, I mean there's a phrase for it for rules. It's like
So there's a strict interpretation of the Constitution versus the loose interpretation of the Constitution. And I personally would say that
Sorry to interrupt. Do you think you could start over? The echo, I didn't catch anything.
Oh, that's okay. So his question was if I'm sorry, could you repeat the question actually?
my question was like in the past, some of the cases with the Supreme Court, like I think Marbury versus Madison, not Marbury, which was versus the state of Maryland.
Yeah, versus state of Maryland.
It was more lenient because that would seem to have to do with more personal matters. Like you felt like you got cheated by the banker. My question was like, because of that, it was the Supreme Court not necessarily always have to do with the Constitution. Is it more lenient in the past or something like that?
And so, did you guys get the question? So, I personally would say that they've actually maintained a kind of even level as far as whether they, as far as judicial decisions. When we'll get to this thing called judicial activism, and that is where a judge makes a decision based on kind of personal beliefs rather than a strict interpretation of the Constitution. That's more a loose interpretation following, and that leads to kind of establishment of laws in the U.S. And that's something that people have a big issue with. And so personally, I would say that they have increased their judicial activism, but and they were stricter in the past because that Supreme Court ruling that you're talking about with the state of Maryland, they ruled in favor of the federal government because federal authority trumps state authority always. So personally, I would say that they've really kind of just maintained a kind of even, whatchamacallit, interpretation of things. And of course, that always that varies from judge to judge, and the composition of the Supreme Court at that time. For example, Judge Scalia, who just passed away, he was a strict Constitution hardliner, and so all of his decisions were more federally inclined, for example. Does that kind of answer your question, Trainer? And for you two, did I complicate things more, or did that make sense?
It makes sense.
Okay. So let's go to the writ of habeas corpus. What is that? You're muted.
It's like show me the body first. I might be quoting it wrong, but it's Latin for it's like having correct evidence or something like that. I'm sorry. Somebody else take over.
Well, the denotative definition is when a person can report an unlawful detention or imprisonment before a court, usually through a prison official.
Mm-hmm. And so habeas corpus is just holding somebody without telling them what they're charged with. And so this writ is kind of a challenge to that. To be like, hey, these guys are holding me and they haven't told me what I did wrong and why they're holding me, but they're holding me.
Oh, so this is basically the act of doing that. So basically calling them out.
Yeah. And yeah, that's editorial note. Sometimes presidents have suspended the habeas corpus because they see a person as a threat to national security. That is the reason why Guantanamo Bay still exists. Yeah, those people aren't directly charged with anything. That's a whole other thing. And so, what is the Chief Justice?
So it's just a justice on the Supreme Court who presides over the court's public sessions.
Mm-hmm.
That's it.
So basically the top dog in the Supreme Court, the presiding judge.
Yep. And they're usually the ones who present the public with their final decision on a case. Whatchamacallit, like, let's say in the Marbury versus Madison case, that was one that you guys have had to read, correct? In that, Chief Justice John Marshall established the principle of judicial review, which is that the Supreme Court can look at the constitutionality of an act of Congress and deem if it's constitutional or not. That's kind of Marbury versus Madison and why that's important. So, and actually, speaking of judicial review, that's our next term. So, does that make sense, what judicial review is? Okay.
So and so, yeah.
What are you confused about?
Well,
Somebody else might be confused too, so.
I don't know if I'm understanding it correctly, so.
Tell me what your understanding is then.
So I just kind of, how do I put it in my own words? Because, like, I have the definition, but, like, I don't understand it. So, like, basically, like, can you basically explain? Because the definition says, a review by the U.S. Supreme Court of the constitutional validity, so basically how credible it is of a legislative act. So is it basically like how credible an act is?
Yeah, it's basically, so if a bill is passed by Congress and stuff like that, then it is subject to judicial review, which is the Supreme Court justices looking at the law and seeing if it's legally valid according to the Constitution. So let's say they passed a law where they could, waterboarding was allowed again. That would be subject to judicial review, and under judicial review, they would rule that would be unconstitutional because it violates the Eighth Amendment against cruel and unusual punishment. Does that make more sense? You're muted, so I just want to make sure.
Yeah, it is. I'm writing notes.
Oh yeah, okay, cool. Let me know if you're ready to move on. Okay. So what is standing besides the act?
The right of an individual or organization to initiate a court case?
Yeah. So basically being like, hey, I want to have a case about this. Who is the Solicitor General?
Is the top government lawyer in all cases before the Supreme Court where the government is a party?
Yep. So basically they're the person that's chosen to present the case to the Supreme Court. And let's say if it was a case against a state, then the Solicitor General would represent the side of the state. That make sense? Cool. What is judicial restraint?
You said before with the interpretation of the Constitution, to use judicial restraint would be more stricter reference to the Constitution instead of the next term is more loose. So it depends on if the justice wants to, because they're not supposed to make waves. You're supposed to strictly confine to the Constitution, but sometimes when it comes to especially important cases within like civil rights or something like that, if you have personal standing within it, then sometimes you are more activist. Sometimes usually it's when you talk about conservatism, they're more restraintive, and then a liberal would be more active. But that's generalizing. But that's how it usually turns out. So not always like Justice Black is all over the place, but really interesting guy. That guy, really interesting. Justice Black.
Yeah. So did everybody understand Trainers explaining?
I might have been muted.
Yeah, but I mean, yeah. Mm-hmm.
Okay.
I just basically get it as like it encourages a judge to limit their own power, like to strike out bills, like for example. So they're talking about bills and stuff like that seem they're obviously unconstitutional, but not to over practice their power. Not to over exercise their power.
Be judges, not legislators. So, would somebody like to explain what judicial activism is to kind of complement Trainer's explanation of judicial restraint?
I read that it meant a judicial philosophy that posits that the court should go beyond the words of the Constitution or a statute to consider the broader societal implications of its decision?
Yeah. So, can you try putting that in your own words?
I was gonna ask you. I found that vocab word a little difficult to understand.
The activism part or the which part?
Like, what do they mean by judicial philosophy?
So it's basically the belief that a judge has as far as how they think they should act as a judge. So the examples of the two main philosophies are the strict interpretation philosophy and the loose interpretation philosophy. And so in judicial activism, they have a loose interpretive policy because, as you said in your definition, they think the Constitution should go beyond what is directly written in it. Does that make sense to everyone? Okay. What is a class action suit?
It's a legal action. Sorry. A legal action by which a group or class of individuals with common interests can file a lawsuit.
Mm-hmm. So basically, if a group of people was wronged by a company that they worked for example, they weren't given, weren't insured their 30-minute breaks after working 4 hours, then those former employees or current could file a class action suit against the company together so that they can be compensated for the injustice that they suffered.
Isn't it a settlement?
Yeah, settlement is a way to settlement is settling a case without taking it to court. And so being like, okay, we promise to pay you $1 billion if we don't take this to court, where both sides would incur costs from the attorneys that they have to employ. So, does that make sense?
Yeah, okay. Well then, all right, I understand that part, but okay, I see that. So then if someone is doing a settlement, they're not, it's basically, it's kind of the same thing as getting sued.
Mm-hmm. Yeah.
So they just don't take it to the courts?
Yeah. Basically, you settle it out of court, and then if not, then you file the class action suit. And
so then is sorry to interrupt.
Okay.
So then why can there be appeals to a settlement? Because I know, like, I did some research projects on, like, CTE, like the brain injuries that football players were going through. And I know there's an ongoing settlement right now that's happening, and, like, they're not getting their money yet because due to a fact of appeals. From the company, not from the players. The company has appeals. And it was basically the NFL, because the NFL is the one that's getting sued. The NFL is they're bringing up appeals that's lasting longer to compensate the families.
Yeah, so probably they settled it, and then they weren't happy with that settlement, and so they decided to bring it to the Court of Appeals. But honestly, I can't say too much because I don't know that much about American law and how the whole settlement process goes. So that would be my guess. Don't take it as the end-all be-all answer. I would say ask your criminal justice professor. Hernandez would have a better idea than I would.
No, because if I ask him, he'll go on forever. We could not talk about our final. I think I'll just Google it later.
It looks like you asked after class, not during class. All right. So are you guys good with all these concepts?
Yeah, they're fine.
Okay. With no objections, I am going to move on to Federalist 78. So I actually, what I really like doing is just cutting and pasting the article into a Word doc where I can bold and highlight it. And so I actually started doing some bolding myself, like 15 minutes or so before this class. And so I didn't completely finish, but I bolded some things that might kind of help clarify the thick-ass wording of Federal 78, because I know it is sticky stuff to go through.
Did you put it on SexCT?
Yeah.
Bolded?
Yep.
Okay.
I haven't put it on StackCT yet. Because like I said, I just did this. So I might clean it up after class and upload it. But for now, let's kind of just go through what I do have bolded to maybe help clarify the point of this article. So, did you guys kind of understand what the main gist was? Or were you just completely lost?
I thought I had a clue, but then I was lost.
Okay. Well, all right, let's take it from the top. So, Federalist number 78, the Judiciary Department. So, we know it'll be about the judiciary. I would say, so we proceed now into an examination of the Judiciary Department of the proposed government. So basically, he's like, okay, let's examine the Judiciary Department and decide if how we want to set it up is going to be the most beneficial for our government. And so he actually outlines it into three main points. The first is the mode of appointing judges. The second is the tenure by which they're able to hold their places, so their term limit. And third, the partition of the judiciary authority between different courts and the relationship between each other. And he's saying these three things are why the way that we have the judiciary set up the way it is a good thing. So, first, the mode of appointing judges. It's the same of appointing officers to the Union in general. Hamilton is referring here to the nomination by the president and confirmation by the Senate. So he's saying, okay, the appointment, we've already discussed that, having a nomination by one branch, a confirmation by another is going to give us the most balanced and best people for these jobs because you have the checks and balances. And so, secondly, to the terms of the judges, he thinks all judges who may be appointed by the United States are able to hold their offices during good behavior for a lifetime tenure. So, I mean, the stress is definitely on, you have to be a lawful citizen to be a judge. You can't just get this lifetime appointment and be like, well, I'm doing coke and getting some prostitutes and stuff now that I got this lifetime job. Don't gotta worry anymore. Especially because, you know, they're judging others, so they should have a good character themselves to actually pass judgment upon others. And moving down, he argues that in a republic, it is no less excellent barrier to encroachments and oppressions of the representative body. And it's the best way which can be devised in any government to secure a steady, upright, and impartial administration of laws. So by having these lifetime appointments, they're able to have more impartial administration of the laws, because if you're appointed for a lifetime, you don't have to worry about, you know, getting reappointed to your position. You don't have to do political favors or anything and play the right side, because you don't need to. You just need to follow the Constitution. It creates much more objective rulings. And so he goes on to say that the judiciary will always be the least dangerous to the political rights of the Constitution, because they'll be the least in capacity to annoy or injure them. Because the executive not only dispenses power, but also holds the sword, the military power of the community. And then the legislature not only commands the purse, the budget, but prescribes the rules by which the duties and rights of citizens are to be regulated. But the judiciary has no influence over either the sword or the purse. No direction either of strength or of wealth of the society, and can take no active resolution whatever. They merely are judgment and must ultimately depend upon the aid of the executive arm, even for the execution of its judgments. So basically, he's saying because it doesn't have military power or monetary power, the judiciary branch is going to remain more objective. So and so it proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power. He goes on to say that individual oppression may now and then proceed from the courts of justice, and the general liberty can never be endangered from that quarter. So he means as long as the judiciary remains truly distinct from both the legislature and the executive, it can't oppress people as a whole, because it doesn't have that amount of power. There might be individual cases where one ruling may not have been better than the other, but in this case, it is not. Can somebody read the next bolded thing? I just said remains truly distinct from both the legislature and the executive.
Is that correct? There is no liberty if the power of judging be not separated from the legislative and executive powers.
So, what does that kind of say?
Basically, like saying, like, they're like, in order for something to be done. So, that's when they're referring to the liberty. They're basically the legislative branch and the executive branch, meaning their powers need to be separated.
Mm-hmm.
In order for something to get done. That's the way I'm taking it in.
Yeah.
Well, you can't. I think they also mean by the fact that you can't be like judge, jury, and executioner. Like, it's kind of if you have Congress have the power of the judiciary, then they can make the laws and enact the laws however they want. And if you were to give the executive branch the power of the judiciary, it also wouldn't really make sense because they can just like release people, like because the president has the power to release people. So it's like, well, it's kind of odd there. And also the fact where the president also has a lot already to manage, especially because the executive has to deal with the foreign affairs and everything else, and now has to deal with like homeland affairs as well, as it kind of overloads one branch. So.
Yep. Way too much power.
Well, that's what federalism is all about, the separation of powers.
Exactly. So, I'm trying to. Okay. Can somebody read where I have highlighted the bolded part, where it starts with no?
No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal. That the representatives of the people are superior to the people themselves.
So, what do you think he's saying here?
So nothing that's unconstitutional is valid. Because there's nothing that, so that's when he says, does it representatives of the people are, so basically, if, to deny this would be to affirm that the deputy is greater than the principal. So like basically saying, we can't do anything that's unconstitutional because it's basically going over the people. That's when it refers to the deputy is greater than the principal. The principal referring to the people. So that the representatives of the people are superior to the people themselves, that's just not something to do. That's unconstitutional itself.
Yeah. A legislative act written by Congress is going to be lower in ranking compared to anything that's written in the actual Constitution, because that is our fundamental law. And to put anything above it would be saying that what the representatives of the people are wanting is superior to the people and the Constitution itself. Can somebody besides Betty read this next bolded point?
That the courts were designed to be an intermediate body between the people and the legislator in order, among other things, to keep the latter within the limits assigned to their authority.
So, what does that say, Camille? What would, so an intermediate body, what's the purpose, what's that?
So they're aren't they trying to say it's like not like picking a side, it's like in the middle?
Yeah.
Yeah.
Mm-hmm. It's what's in between the people and the legislature. And
Okay, that's what they mean by the keeping the ladder within the limits assigned to their authority. So basically, like, the people only have a certain amount of stuff that they can do. So basically, they can bring something up to basically, what they're referring to the bodies of power, and then the bodies of power only have so much they can do authority-wise. So people have authority, bodies of government have authority, but we need both to do something.
yeah, and as a in-between body, intermediate, they keep the legislature from running away with that power. They keep the ladder, the legislature, within the limits assigned to their authority. So think of judges as the referees to a game, and all the legislators are the players, and the people are the audience watching. And to conduct a valid game that is fair to the audience and what they paid for and what they're there to watch, the referees keep the players in line with the rules. Does that make sense?
But without the referees, you can't do anything. Basically, you can't claim an injustice by yourself.
Yeah. And you don't, like, yeah, without the referees, there's no red cards or yellow cards, or people can play soccer with their hands besides the goalie. So, an important point to follow up with that bolded one was this conclusion does not mean, it doesn't suppose any superiority of the judicial power over the legislative power. It supposes the power of the people of the Constitution is superior to both. So basically, they're just kind of enactors of the power of the people. Yeah, there's a bit more and stuff like that, but Hamilton's main point was that the judiciary isn't something to fear. It's the weakest of the three branches because of the way that it's appointed through a check and balance system, the lifetime appointments, and the fact that we have different sets of courts that build upon each other. I will, like I said, I'll clean this up and put it onto SACCT if you want to read it and stuff like that.
What do you mean they were appointed by checks and balances?
Appointed by the president and approved by Congress.
Oh, got it.
Yeah, sorry.
No problem.
And so we didn't get to stuff that is technically assigned for today, but I would highly recommend that you read the justices with daughters and I was Alabama's top judge articles, because you may ask about them and you don't want to be left in the dark.
They're good.
Yeah.
The first one was pretty good. I skimmed it. So guys, if you guys skim it, I mean, they're very straightforward. It's not one of those, not like federalism. That's why I didn't ask the question on federalism. But I didn't ask a question on those. But the first one, basically just talking about how there was a case, for example, said that congressmen vote more liberal when it comes to things like abortion and stuff like that. If they have a daughter, like they're more, if they rule more so to the feminine side, if they have a daughter.
Mm-hmm.
And then the second one was basically a top dog. She was a woman. She made it, and she saw the whole process of how she made it, and she freaking hated it.
Mm-hmm.
She knew it wasn't clean. She didn't like where the money came from, and she just hated it. She was there, but she hated it. It's literally what it is.
Because the issue with that article was that she actually had to run to be elected to be a judge, and kind of that goes contrary towards Hamilton's belief that, appointments through merit rather than through elections is a better way to appoint judges, because they aren't dependent on political things. And that article really does a good job of explaining the issues that come with electing judges.
Honestly, before reading this article, I had no idea that judges can run.
Yeah, exactly.
I thought they were always appointed.
Mm-hmm.
So I learned something new today.
Yeah, I remember I learned that too when I first read it. So it's informative stuff. Do you guys have any last questions that you want to address before I let you go?
Feels pretty good.
Everybody good? Okay. Well, we have one more class on Wednesday, and then you guys are free. So please show up.
For me, just in case, I might or might not. It's a 50-50. I'm not sure yet. So I might or might not show up. It's my mom's birthday, but it's like,
Okay. Yeah.
I mean, since I'm here and over there, it just really depends if my older brother goes, and if he doesn't go, then I'll connect. If not, I'll make up the work, and so and so. But just a little heads up. And just in case I don't, some people of you guys, I don't see you guys in class, so it's really cool talking to you guys every once in a while. Hope everything goes good in finals.
Yeah. And also, if you're not here on Wednesday, I do want to thank you guys for being a really great class. You're honestly one of my favorite classes that I've taught. Also, you guys talk to me.
Thank you.
Things are so much more engaging rather than me just talking. But yeah, so I want to thank you guys. But that's that. I hope you get good luck on all of your finals. I know you will rock them. You're amazing students. So yeah, good luck.
Thank you.
Thank you guys.
Bye,
That might
everyone.
be a bit more to say, but I do.
Thank you.